Yes.
And are you satisfied with the services?
Yes.
Do you have any questions for the court or for your attorney before I proceed?
Oh, yeah.
Then as to count 4, battery, how do you wish to plead?
Guilty, Your Honor.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of.
This is the turning point of the case. A guilty plea doesn't just end the trial, it ends the fight. No jury, no witnesses, no second chance. When the judge says knowingly and voluntarily, it means this decision is permanent.
Battery. The other counts will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. Argument, Mr. Schmidt.
I think the court needs to place the defendant on supervision. I think what the court's heard today from the victim is extremely impactful. And I want to be clear. I believe that it happened the way the victim described it, full stop. However, I am not the plaintiff for Mr. Joerger in a civil case alleging a tort battery, which would be how you describe a situation where you go in front of a jury or a judge and say, hey, who do you believe? Do you believe Mr. Morse or do you believe Mr. Joerger?
Here's what most people miss. This is not a civil courtroom where credibility decides everything. This is criminal court, where the state represents the public. The standard is higher and the consequences are real.
I'm representing the public interest, and I'm representing to the court about what we can know to 93% chance 10 guilty people go free is better than 1 innocent person being convicted, Blackstone's ratio. To that end, what I would say to the court is, because of the nature of his past conviction in 2008, albeit extremely long ago, the court should have paused to place him on probation still now. The reason for that is the 2008 conviction also involved assaulting a family member. It was also involved holding a metal object. In that case, it was a pistol and a flashlight where he struck a family member on the head, causing head injuries. This is similar, very different object. The victim believes it might have been brass knuckles because he's aware that Mr. Morseth owns brass knuckles. He couldn't see very well, knew it was something metal. Mr. Morseth, when he was interviewed, said, I was holding my keys because he was changing the locks at that shed, and it was the keys he hit him with. So it's still a metal object either way. And because of the 2008 conviction, he should know how serious hitting with any metal object can be, whether it be.
Notice how the prosecutor isn't focused on the exact weapon. The argument is about pattern. Similar behavior, similar harm. In sentencing, patterns matter more than details.
Brass knuckles or keys or a flashlight or a pistol. Because of that, and because of also, Mr. Joerger alluded to in the family, there's lots of concern about him that goes beyond the 2008 conviction. Whether there's some allusion to it's not physical, but everyone's afraid of him for some reason other than physical. That's another reason for the court to have pause and wonder if there's anger management issues or if there's a greater domestic violence issue that needs to be looked at for Mr. Morseth. I know this isn't domestic violence because obviously Mr. Morseth has not lived with the victim here. But when I use the term domestic violence, I'm not using the statutory definition. I mean, violence against somebody in the family, which I think is probably the layperson understanding of the term. I think that the court's likely going to hear something to the effect, hey, judge, this happened in 2004. He's been on bond. He hasn't done anything since. So there's no need for probation. To that, I'd say just because he's been on bond doesn't mean he's been doing interventions, doesn't mean he's been doing MRT or thinking for change or cognitive thinking things that could benefit his family. And it doesn't give the victim the added benefit of
Probation isn't always mercy. Sometimes it's control. The state frames supervision as protection for the victim and for the public.
At least some peace of mind that DOC will be monitoring him for this time. Thank you.
Thank you. Mr. Davis.
Thank you, Your Honor. Well, Your Honor, I believe it's a serious offense because it's a criminal conviction, albeit a misdemeanor. He's still not convicted of a misdemeanor battery. But when I look at, I've heard the victim, I've heard his position, I've heard the state's position, but my client has not changed the position one bit. My client did not start the fight, was not the aggressor. He was at his grandmother's farm. He had permission to be there, and no one had permission to put a lock on the shed. And the grandmother instructed my client to remove the lock, and he did so. And that really upset the victim to no end. And the victim was the one who started this, was getting in my client's face, and then the fight ensued. My client never had brass knuckles. He never had any kind of weapon like that or anything. The reason he had keys in his hands because that's what he was carrying. And as he was getting choked and beat, and he was fighting back, it would be the only thing that he had in his hands. Metal would have been a key or keys that he had, which he was out there with. But he wasn't using them as a weapon. He was getting attacked. I believe that my client could have stopped when he got the advantage. And I think at that point when he didn't, I think he even told the officer it was fight or flight. And I think his adrenaline was so much as that he continued fighting when he could have.
This is a risky defense strategy. By admitting the defendant should have stopped, the conviction becomes unavoidable. From here, the goal shifts from innocence to damage control.
Clearly stopped. That's the battery. He had no permission to continue on. It should have been ended, and they both should have gone their separate directions. He's now guilty of that. But I would like the court to be aware, the victim is talking about this, but there's been lots of issues at that farm, include Dennis Steverman and Wyatt Steverman would be the nephews of the victim and my client's cousins, who had also had altercations with the victim at the farm. Because the victim wants to pretend that it's his farm and he doesn't like any other family members out there, and he tries to control things. Now, my client, I'm here to argue and let the court know why the victim was the aggressor and why he was out there. My client has permission from his grandmother to be out there, and anytime he's out there, he gets permission from her. And it seems that the victim doesn't like my client or any other nephew out there, and he doesn't like it and he doesn't want anyone out there. But in any event, this is not the first instance that involved my client and physical altercations. It's also been two of his cousins that have had to be in similar situations. Maybe not to the extent of this, but it's an unfortunate situation. But I don't want the court to think that my client is a dangerous human being and he's out there trying to impose his will on anyone that's at his grandmother's farm, because that's not true. Another thing is a little disingenuous is for 20 years, he's been known that my client's dangerous or he's fearful. 20 years is a long time to contact law enforcement or get restraining orders if those types of activities were occurring. I don't believe they were. I think there were also concerns of alcohol use, not by my client, but by the victim. And it has not been the first time that's been a problem out at the farm or other places near the property. In any event, my client's here taking responsibility. He now has a conviction, battery conviction on his record. What I want the court to know, and yes, we are thankful, my client is thankful, you gave him the opportunity to keep making money, and he worked lots of overtime to pay that restitution up front, Your Honor. And that restitution amount was, I thought, one of the more significant amounts that I've ever had a client come up with, which I believe was $5,909.06.
It was revised to $6,872.84.
So even more than the initial amount that I had then.
Nearly $7,000 paid before sentencing sends a powerful message. In court, action speaks louder than apology.
And he's paid that, and he had to work additional shifts. He works out of town. As you allowed him to do that, he would go and he works in Minnesota or another state, and he was able to pick up additional shifts to make sure that that restitution was paid. Again, and the reason I'm making an argument for cost on this, it's not just because he's paid the restitution. And my client does not want to have any contact with this individual. And my client still has a great relationship with his family, maybe not the victim's wife. And I didn't know that the victim and his wife were even still together. I know there was issue with those two within the past year or two. And I think the state's aware of that. But in any event, my client wants no contact with the victim. He doesn't go or do drive-bys. He doesn't go anywhere near the victim and never will, period. Never, ever happen. He doesn't want anything to do with that part of the family. But I can tell you that Nicholas wasn't drinking, Nicholas wasn't using drugs, and he's never had a problem with drinking or drugs. He's made all his court appearances. I know this has been very serious for him. He's been very stressed out about this. But I think that putting him on probation, yes, the state then, the Department of Corrections can monitor him and make sure nothing like this happens. The last time it happened was 17 years ago, 18 years ago, where he had his one misdemeanor. That's the only record he has. That is extremely long time ago. But I think that probation may not be well suited because I think those resources could go to people that have addiction issues or need special treatment and things like that. And while I do agree with the state, because I'm not going to lose my reputation in this court or any other court, yes, I agree that the damage was much worse on the victim than it was on my client. That's factual. So I will agree with that. But my client was roughed up very well too, but not to the extent as the victim. But my client does not have any bond violations. He's never tried to mess with the victim, intimidate him, hasn't talked to grandma or any family member about it. He has stayed completely clear of it and followed every court order. And so I think he's earned the right. He's now a convicted criminal with this today. And I think he's earned the right for this to just be a court cost and fine. And again, I'm not trying to be insincere about this, but again, my client did not start the altercation, but I do believe that he could have stopped at the appropriate time. And again, the fight or flight is adrenaline. He continued on, and it should not have happened. And for that, he is wrong, and he should have never done that. And he does apologize for it. Nick is a very shy person. He doesn't do well talking. As you can see, even when he's answering your questions, he's shy. So I'm speaking on his behalf today, Your Honor. Thank you very much.
All right, thank you. I know you said you're speaking on his behalf here today, but Mr. Morse, you have an opportunity to provide anything to the court, to let me know anything you want me to know. If there's something that wasn't touched on, or if there's something that you feel needs to be corrected or you need to add, this is your opportunity.
Yes. Yes, Your Honor, I'd like to say something.
Then please put the microphone closer to your mouth.
Is that
Thank
better?
you. Yes.
Is it on?
Yes, it is.
Yes. My uncle, Rick, I looked up to this man for a very long time. It was a bad situation, like you said in the previous hearing with this. There's victims on both sides of the spectrum. I remember that. I remember you saying it clear. And I feel like I was a victim, and I'm sure he feels like he was a victim. Should have never happened, or should have never got to that far on both sides of the spectrum, where he aggressively attacked me, not just once, but 3 times too. Kept coming at me. That's where I come up with I said the fight or flight reaction. I could not get away. And I kept telling him, stop. When we were on the ground, stop. Where's your glasses? Where's my glasses? And after he punched me in the private area, I ended up kneeing him in the face. And that's how the glasses got broken. That's how the black eyes happened. That's when he finally stopped. I said, stop, Rick, we're done. No more fighting. I don't want to do this. And that's when I was able to.
Emotional testimony matters, but it doesn't erase harm. Judges may listen with empathy, but sentencing is still about accountability.
Actually vacate the property. But not until then. He mentioned to me, and I was scared for my life. He said, basically, I'm going to kill you. And I know he has a conceal and carry license. And that's when he had that. He got that prior to before traveling for his safety and his family. I think he has I believe that he has some mental anguish of fear for his life from his travels. And I have no intent to do any harm to him, his family, or anybody. It was just a bad situation that it blew up and it got worse. And I've learned from my mistakes, and I'm just as anybody else learns from their mistakes. If they can learn, they're going to better themselves, Your Honor. And this has been a long haul for me, this whole time. Working, bonding, making memories with my kids, because I had reconsidered that, and it's been hard. It's been hard for me too, physically, emotionally, because I might worry about seeing my grandma if they're there. So I call, I try to avoid them so there ain't no two people at the same time with the restraining order. It's been hard. And I know my grandma's getting up there in her years, and I don't know how much more time she has left. So every moment I can spend with her, it's a gift.
All right, thank you, Mr. Morseth. Well, in sentencing an individual, you haven't been in front of a court for sentencing for a very long time, and things have probably changed since 2008. The court needs to look at the nature and the gravity of the offense. How serious is this case? I have to look at you, your character, your past criminal record, any rehabilitative needs you may have, among other things. I have to look at the need to protect the public. I have to look at the impact on the victim. I have to look at other things as it relates to the public and the public interest. In looking at this case, you are pleading guilty to a battery, to laying your hands upon another person without their consent and injuring them. That is serious. That's a serious crime. You've done this before in 2008, and it sounds pretty similar from the 2008 conviction. So that's on the negative side. On the positive side, you haven't been convicted of anything similar since 2008. It sounds like that there's a lot of family discord. It sounds like, but it's hard for me to gauge and hard for me to tell. The victim, Mr. Joerger, was very convincing, and this has impacted him significantly. And I understand it has impacted you as well, but you're the one seated in that chair. You're the one who is now convicted of the battery. What exactly happened that day? I don't know. The only two people that really know are you and Mr. Joerger. Only you two know exactly what happened that day. And it sounds like it was awful, traumatic, not only physically, but emotionally as well. And it didn't only impact you two, it impacted your family and others. And that again makes this a more serious crime. You did plead guilty. You are now, again, a convicted criminal, I guess. You are a criminal. You've been convicted of a crime. You worked hard in order to pay off the restitution, and almost $7,000. That's a lot of money to prepay. And you prepaid most of your court costs and fees ahead of time. So to the court, that looks like you're taking it seriously. There are some things to consider with the state's argument in the fact that there are things that perhaps the court needs to look at. Because again, even though it was from 2008, it is so similarly related of a crime that there's something that goes into that. In protecting the public here, number one, it's protecting Mr. Morseth. Sorry, not Ms. Morseth, Mr. Joerger, protecting him and protecting, his environment. And then the court also has to look at others. Do you have needs that you need to address? Are there resources that you need to reach out to, such as anger management or criminal thinking programming, like Mr. Schmidt has argued? When we're looking at this case, I think it is a positive that you've prepaid the restitution. It is a positive that you are admitting to your guilt. But I do see the state's perspective and argument that there could be other things that you need and you need to address. But that would be up for probation to determine. Probation's the one who will know if you have things you need to do, or if there aren't things that you need to do, how often you need to see probation, if at all. But I think the seriousness of this case does call for probation. So I am going to order 1 year of probation
1 year probation. A suspended jail sentence. This is leverage, not leniency. One mistake, and 9 months of jail becomes reality.
1 year of probation, and I am going to do a withheld sentence. Generally, I would do an imposed and stayed sentence, but quite honestly, I want you to understand that there could be a seriousness of 9 months of jail hanging over your head. So if you aren't going to abide by your conditions of probation and do what you need to do, you could go to jail for 9 months. That's a significant amount of time. I believe you were arrested, but I don't know if you've sat any days in jail. Any overnights?
No.
Overnight, I believe.
It was overnight?
Yes.
So,
Oh, no, it was actually longer than that 'cause I got transported down to Polk County. So I don't know how many days it was.
Judge, I'll have to look into that. I don't have the amount of the days.
so, okay, well, let the court know within 7 days what the jail credit is. But Mr. Morse, you could have 9 months of jail. That's a significant amount of time. I do want to see as conditions of probation, an anger management course with the department's choosing, and a criminal thinking program. Absolutely no contact with Richard Joerger or his wife, but there's a restraining order anyway, an injunction. No abusive contact with any family member. Absolute sobriety. You don't drink or do drugs anyway, but probation won't allow you to do that anyway. I'm ordering restitution in the amount of $6,872.84. $518. Oh no, actually $500 in fines and fees. So I guess you have prepaid your court costs as well. You should have all of that covered. Any conditions that I'm missing for probation?
Not for me.
You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. The court is going to order your DNA. You have to provide your DNA to the sheriff's department. This would be a crime that you could request it be expunged through a written letter to the Department of Justice. You do need to report to probation immediately.
Restitution, the last one we had was.
There's a revised, there was a revised one on August 6th. Was there a revised one to a lower amount? On May 30th,
No, I've got the receipt right here, Judge. You were right. The $6,872.84.
Yeah, he paid $6,000.
And he's got the receipt for it as well.
There was one in there. Document 16. For $6,872.84.
Well, he's got document 15 on his, but anyways.
Well, yeah, mine is the sealed one.
Oh,
So it's document 15 is the one.
Document 39.
So I'm not sure exactly what the restitution is. He's prepaid $6,872.84. That's one of the restitution supplements that we have. 20 days to appeal. You need to contact probation. Is your address 28482 Fox Ridge Trailway?
Yes, Your Honor.
Telephone ends in 3699. You must report to probation immediately. I believe they close at 4, I think, I'm not certain, but I am going to give you until tomorrow at 4 to report, just in case they are closed. So again, provide your DNA, go to probation and get that set up. and you should be free to go.
We'll talk next week. Make sure you sign up for
And
probation.
we are adjourned.
No.
This
This
case
case
shows
is
how
a reminder
quickly
that
family
in family
conflict can turn
disputes,
criminal.
history matters,
In the end,
and escalation is
probation
everything.
wasn't a reward.
Guilty plea or
It was
not,
a warning.
the court
Your Honor, where's the probation office?
It's kitty corner off the highway.
Oh, over.
Yeah.
Okay. Where was that?
So go see if you can get there today.
Yep.